Hello, this is Wole Araromi, partner at Lex and Sophie from Lagos, Nigeria, and you're listening to IP Friday podcast.
Hello and welcome to this episode of IP Fridays. Our names are Ken Suzan and Rolf Claessen, and this is the podcast dedicated to intellectual property. It does not matter where you are from, in-house or private practice, novice or expert. We will help you stay up to date with current topics in the fields of trademarks, patents, design and copyright, discover useful tools, and much more.
I am Rolf Claessen, and you are listening to episode 168 of our podcast IP Fridays. My co-host Ken Suzan has interviewed Wole Araromi about the registration and enforcement of trademarks in Nigeria. But before we jump into this great interview, I have news for you. The US patent system is currently undergoing significant changes. The new USPTO director, John Squires, is taking a hands-on approach to the inter partes review (IPR) process. As of October 20, he announced that he will personally decide on all IPR and post-grant review cases, removing this authority from the PTAB panels. At the same time, the USPTO published a proposed rule introduction mandatory exclusion criteria for IPR petitions. These measures, accompanied by a wave of discretionary denials since early 2025, are aimed at strengthening the position of patent holders and limiting review procedures that have often favored defendants. In practice, this is expected to significantly reduce the number of IPR filings and marks a politically driven policy shift in favor of patent owner rights. Meanwhile, US patent legislation remains in flux. Republican Congressman Thomas Massie has announced that he will reintroduce the RALIA bill, Restoring America's Leadership in Innovation Act. If passed, it would bring sweeping changes. The Patent and Trial and Appeals Board, PTAB, established only in 2012, would be abolished. The US system would revert to a first-to-invent regime, and the automatic publication rule for patent applications would be repealed. According to Massie, the goal is to roll back what he views as harmful reforms of the past decade and provide stronger protections for inventors. However, observers doubt whether this proposal has any realistic chance of becoming law. Competing bills like the Patent Eligibility Reform Act are already more advanced, and full abolition of the PTAB is seen by many as politically unfeasible. On the international stage, a novel patent dispute over FRAND licenses made headlines. For the first time, the Unified Patent Court, the UPC, and the Munich Regional Court issued an anti-interim license injunction in favor of patent holder Interdigital, aiming to prevent Amazon from obtaining a compulsory license in the UK. The response from London was swift. The High Court, Justice Mead, issued an anti-suit injunction prohibiting Interdigital from interfering with Amazon's license proceedings in the UK. This cross-border legal standoff over standard essential patents illustrates the increasing complexity between the UPC and national courts in a global FRAND litigation landscape. There was also a noteworthy win for patent holders in Germany. A patent infringement case concerning refill cassettes for diaper disposal systems, the Düsseldorf Higher Regional Court upheld an injunction against a Polish imitator. The company Sonesta and its former managing director were prohibited from offering the film refill sets in Germany without clearly indicating that their use was only allowed with permission from the patent holder AngelCare. Notably, the court confirmed the personal liability of the former managing director, as she had acted as the responsible seller on a sales platform. This ruling strengthens the right of patent owners and highlights that even individuals can be held liable if they knowingly facilitate IP infringing conduct in a managerial role. And now let's jump into the interview.
Our guest today on the IP Fridays podcast is Wole Araromi. Wole is a partner with the law firm of Lex and Sophie based in Lagos, Nigeria. Wole is a graduate of the University of Ibadan and the Nigerian Law School. Today, our focus is on trademark registration and enforcement in Nigeria. Welcome, Wole, to the IP Fridays podcast.
Thank you, Ken. It's my pleasure to be here.
Excellent, Wole. Wole, what is the regulatory authority for trademarks in Nigeria?
Okay, that's the Registry of Trademarks, Patents, and Designs. And that registry it falls under the Ministry of Commerce, Trade, and Investments.
Very good. And Wole, how are goods and services classified in Nigeria? Do they follow the international classification system?
Yes, Nigeria follows the NIS International Classification System. So goods and services are classified, in two categories. For the goods in classes 1 to 34, and for services in classes 35 to 45. Yeah.
Mm-hmm. Now, can you file an application with both goods and services listed in one application, or do you regularly split them up between goods and services if there's goods and services to list?
Yes, you're going to have to split them up because it's a mono class application system in Nigeria. So the application is filed per class, per trademark, per class.
Got it. And what are the requirements for the registration of a trademark or service mark in Nigeria?
Okay. The requirements are kind of similar to what obtains, almost everywhere else, i.e., you have to submit with your application. You have to submit an electronic copy of the trademark, preferably in PDF file. You have to provide the details of colors if the applicant is claiming any colors. Also, you have to state the class and the specification of goods and services. You have to provide the full name and address of the applicants. And if the applicant wants to claim priority of a foreign trademark application, he has to provide a certified true copy of the home application.
Mm-hmm.
Yes, and all these documents have to be in English language.
Okay.
And particularly the priority document, if it's not in English language, it has to be a notarized English translation. That will be acceptable.
Okay.
And of course, finally, a power of attorney.
Mm-hmm. That's right.
Which is to be simply signed. It does not need to be notarized or legalized. Just simply signature. Simple signature is required.
Very good. And what about timing? Generally, how long is it taking to register a trademark in Nigeria?
Okay. Ordinarily, for a straightforward application, it will take about two years thereabout. 2 years, 2.5 years. Thereabout. However, the registry experiences some problems, quite
Sure.
a number of times. So it's usually for some time now, it's been taking longer than that, much longer than that.
Mm-hmm. Is there a way to expedite, for example, or everything goes the normal standard track?
Yes, some applications can be expedited, but if a problem at the registry is a technical problem with the platform, there's nothing that can be done because it's the registry that has to fix that. And until the platform is fixed, there's nothing that can be expedited.
Mm-hmm. And do you file everything electronically, or is it the old-fashioned paper method?
It's both ways now. Partly electronical, partly manual, which is the WIPO provided iPass system.
Okay.
Yeah, provided by WIPO.
Let's talk about specimens of use. Is evidence of use required to file the trademark in Nigeria?
No. Evidence of use is not required to file a trademark application in Nigeria. However, use will now become relevant if a third party wants to probably oppose that registration, well, don't let me use the word oppose. If a third party wants to kind of apply for that registration to be struck off the register,
Mm-hmm.
yes, if the party can prove that trademark has not been used for some time, like 5 years prior to the date of that application, then the registry will look into that application. So that's when use becomes relevant, when there's
Okay.
an application for deregistration.
And
So
if
in
you
other
had,
words, to keep it active, there has to be use.
that's right. And if the registrant had to show use of the mark in Nigeria, for example, with clothing, what types of specimens would you be able to file in Nigeria?
Okay, now we're talking of use to keep the trademark registered, not for the application, because it's
That,
not required for application.
that's right. Yeah, let's talk about
Yeah,
both.
both. Okay.
Yeah, both situations. What would be an example of a specimen of use you could file?
Okay. Yeah, if we want to prove use, something as basic as advertisement will be
Okay.
acceptable. Will be acceptable, yes. And of course, sales receipts, um, importation invoices,
Mm-hmm.
marketing documents, brochures, and all that. These are acceptable proofs of use.
And that specimen would have to relate to use in Nigeria, correct? You couldn't submit
Yes,
something from
use,
another country.
yes, yes, use in Nigeria because this is the country of interest. This is where the application is being registered or has been registered.
Very good. Let's talk about change of ownership, Wole. Can a trademark be assigned in Nigeria, and what's generally the process?
Okay, yes. Just like any other property, like real estate, a trademark can also be assigned in Nigeria, and the process is well kind of straightforward. The applicant will have to bring an application for that. Then, in support, he has to add the deed of assignment, assigning the trademark to a third party. Then there are two forms, statutory forms that have to be filled by both the assignor and the assignee. And these are forms 16 and 17, which will be obtained from the registry and passed on to the applicants to file. I mean, sorry, to sign, to execute, to fill and execute.
Mm-hmm.
So once these documents are provided, then of course, the deed of assignment has to be stamped at the Federal Inland Revenue Service, and stamp duty will have to be paid on it. Then all these will be filed together at the trademark registry.
Mm-hmm.
They will be vetted, and if they pass the vetting process, then it will be processed and the assignment will be recorded in the trademark register.
Mm-hmm. Switching gears, Wole, let's talk about trademark enforcement. How can you enforce a trademark in Nigeria? And are you finding, for example, on the internet, instances of infringement?
Now, two ways. If the trademark is registered, then the owner or the proprietor or the interested party, maybe a licensee, can commence a suit in court at the Federal High Court. In this case, is the Federal High Court that will attend to that for a registered trademark. He can sue the alleged infringer for infringement of the trademark, and he can claim several reliefs. The first, he can apply for an Anton-Pillar order. Then he can also apply for an order to take down the infringing publication on the internet, the infringing post on the internet, pending the determination of the substantive suit.
Mm-hmm.
Yeah. However, if the trademark is not registered, then he cannot sue for infringement if he's not registered. However, he has a right under the common law, and he can sue for passing off.
Mm-hmm.
And he can do that at the State High Court It could be Lagos State High Court or any other high court of any of the other states of the federation and claim the same reliefs.
That's good to hear that there's some avenue for relief if the mark is not registered in Nigeria.
Yes.
What about international registrations, Wole? Are they effective and enforceable in Nigeria?
Unfortunately, they are not, because Nigeria is not a signatory to the Madrid Agreement or Protocol.
Mm-hmm.
So international trademarks have no effect in Nigeria. So an owner of a trademark would just have to register his trademark locally in Nigeria to get appropriate legal protection.
That's good to know. And there would be that gap in coverage if you don't apply in Nigeria. So it's good to keep that on the list if that
Yes.
market is important to you.
Yes.
Another thing I'd like to talk about today, I know it comes up from time to time, is something known as OAPI or OAPI. What is
Okay.
OAPI and what is its significance? Why should we care about that type of protection?
Okay. OAP is the Organization of African Intellectual Property.
Mm-hmm.
Yes, it's similar to it offers a unified system of trademark registration and enforcement, processing and enforcement. It's similar to the Madrid. It's like the African, well, I won't say African because it doesn't cover the whole of Africa. It's like a regional version of the Madrid system.
Mm-hmm.
However, the difference here is that unlike the Madrid system, whereby a member state can apply from the home states, the registry of the home state, in the case of OAP, a member state cannot apply from the registry of the home state. The application is filed at one point only, and that's the headquarters, which is in Cameroon.
Mm-hmm.
That's the only place where you file the application.
Mm-hmm.
However, once it's filed and the trademark is registered, it is valid, effective, and enforceable in all the countries that are members to OAP. And there are 17 countries
Oh, wow.
17 were French-speaking West and Central African countries. There's French-speaking countries, and there are 17 of them. So that single application covers all those 17 countries. They're enforced there, they're recognized there. Any action can be taken on any of them. It's very powerful and very useful.
Definitely.
Unfortunately, Nigeria is not a member of OAP.
Yeah. So it's important to keep Nigeria in mind, right? If you file that OAPI, application, just so you have that coverage should you need it in Nigeria.
Yes, it is. It is very important.
Very, very good to know. One last question today, Wole, and that is the trends. I'm curious to know, do you see any trends that are happening with respect to trademark registration and enforcement? Have you seen an uptick in applications or enforcement actions? Just give me an idea of what's going on lately in Nigeria.
Okay. Unlike the developed and more developed countries, IP rights, IP law are just catching on in Nigeria. The awareness is just catching on as it ought to be, though we've had an IP law in Nigeria for decades. However, there was very little awareness about it. But in recent times, there's been, a serious uptick. One, on public awareness. Two, in the influx of applications, requests for applications from outside the country, because as you know, Nigeria is majorly an importing nation. We're not really producing much except oil. Oil is our major production and exports. So we import most of the goods we consume in Nigeria. So and of course, IP follows trade. So we have a serious influx of applications from outside the country in recent times. Mostly mostly from Asian nations.
That's
Mostly,
interesting to know.
mostly from
Any
Asian nations.
particular classes that you're seeing a lot from Asia? Is it electronics or other things, or is it across the board you're seeing an increase?
Yeah. When I said mostly from Asian nations, I will single out China as the major one.
Mm-hmm.
China is the predominant nation, followed by India. Now, initially, they were predominantly in automobile and electronics,
Mm-hmm.
electricals and electronics initially. But over time, they have spread across board. And you actually see the Chinese applications in almost all the classes now, because they are producing almost everything now.
Yes.
Yeah, and they want to come to Nigeria because most of these countries view Europe as saturated or getting saturated. Asia too. They're seeing Asia as getting saturated. So they see Africa as the next virgin territory to be explored. So
Yes.
they're coming in here, and when they're coming to Africa, of course, Nigeria is the major consideration, being the most populous, being the largest economy in Africa. So yeah, they've come here, and you see them now in pharmaceuticals, you see them in electronics, you see them in automobile, you see them in clothing, footwear,
Sure.
even in financial services sector, you see them there too. you
Sure.
know,
Yeah, it
yeah,
sounds like across the board there's an increase and an
across the
uptick
board.
in
Yes, you
application.
see them almost everywhere. In construction, you see them there. Security, you see them there. Then the Indians are mainly found in pharmaceuticals. The Indians.
Mm-hmm.
Yes, that's their major focus.
Well,
Those.
it's good to hear from you, Wole, and to get a sort of an understanding as to what's happening in Nigeria, and that there is a definite process to obtaining, registration and enforcement in Nigeria. I appreciate you taking the time, Wole, to speak with us on the IP Fridays podcast. Thank you so much.
The pleasure is mine, Ken.
That's it for this episode. If you liked what you heard, please show us your love by visiting ipfridays.com/love and tweet a link to this show. We would be so grateful if you would do that. It would help us out to get the word out. Also, please subscribe to our podcast at ipfridays.com or on iTunes or Stitcher.com. If you have a question or want to be featured in one of the upcoming episodes, please send us your feedback at ipfridays.com/feedback. Also, please leave us a review on iTunes. You can go to ipfridays.com/iTunes and it will take you right to the correct page on iTunes. If you want to get mentioned on this podcast or even have comments within the next episode, please leave us your voicemail at ipfridays.com/voicemail. You have been listening to an episode of IP Fridays. The views expressed by the participants of this program are their own and do not represent the views of, nor are they endorsed by their respective law firms. None of the content should be considered legal advice. The IP Fridays podcast should not be construed as legal advice or legal opinion on any specific facts or circumstances. The contents of this podcast are intended for general informational purposes only, and you are urged to consult your own lawyer on any specific legal questions. As always, consult a lawyer or patent or trademark attorney. Copyright 2014, all rights reserved.